Thank you for visiting my channel. Before we start, please hit the subscribe, like, and share buttons to receive notification of future presentations. Our topic for today is Lex Loci Celebrationis under Article 26 of the Family Code, first paragraph. Article 26 of the Family Code is composed of two paragraphs. The first one pertains to the application of the doctrine of Lex Loci Celebrationis on foreign marriages of Filipinos, and the second paragraph to the effects of divorce obtained in foreign countries. This presentation will feature only the first paragraph. Another presentation will be prepared featuring the second paragraph. Lex loci celebrationis means the law of the place of celebration. If valid where celebrated, it is also valid here. That is the general rule. However, there are exceptions to the general rule as provided under Article 35, paragraphs 1, 4, 5, and 6, and Articles 36, 37, and 38 of the Family Code. Now let us read the first paragraph of Article 26 of the Family Code. Article 26. All marriages solemnized outside the Philippines in accordance with the laws in force in the country where they were solemnized and valid there as such shall also be valid in this country, except those prohibited under Article 35, paragraphs 1, 4, 5, and 6, and Articles 36, 37, and 38. The prohibited marriages enumerated under the exceptions are void marriages even if valid in the country where they were celebrated. Article 35. The following marriages shall be void from the beginning. 1. Those contracted by any party below 18 years of age, even with the consent of parents or guardians. Relate 35.1 to Article 2 that provides for legal capacity as a requisite of a valid marriage. Parental consent is required under Article 14 where a contracting party is between 18 and 21. Where a minor enters into an ordinary contract, for example, a contract of sale, the contract is only voidable or annullable. But if it is marriage contract, it is void as provided in 35 paragraph 1. 4. Those bigamous or polygamous marriages not falling under Article 41. Article 41. A marriage contracted by any person during the subsistence of a previous marriage shall be null and void, unless before the celebration of the subsequent marriage, the prior spouse had been absent for 4 consecutive years, and the spouse present has a well-founded belief that the absent spouse was already dead. In case of disappearance where there is danger of death, under the circumstances set forth in the provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient. For the purpose of contracting the subsequent marriage under the preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee, without prejudice to the effect of reappearance of the absent spouse. Article 391. The following shall be presumed dead for all purposes, including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage, or an airplane which is missing, who has not been heard of for 4 years since the loss of the vessel or airplane. 2. A person in the armed forces who has taken part in war and has been missing for 4 years. And 3. A person who has been in danger of death under other circumstances and his existence has not been known for 4 years. Take note that under Article 41, for purposes of remarriage, the spouse present can secure a decree of presumptive death of the absent spouse after only 2 years of absence. The requirements of 4 and 2 years are only for the purpose of remarriage by the spouse present. For the purpose of opening his succession, Article 390 of the Civil Code provides that an absence of 10 years is required. However, if the absentee disappeared after the age of 75, an absence of only 5 years is sufficient for the purpose of opening his succession. Paragraph 5 of Article 35, those contracted through mistake of one contracting party as to the identity of the other, and 6, those subsequent marriages that are void under Article 53. For a better understanding of the void marriage under Article 53, I am reproducing here under Article 52 that provides for the requisites of a valid subsequent marriage under Article 53. Article 52. The judgment of annulment or of absolute nullity of the marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimes shall be recorded in the appropriate civil registry and registers of property. Otherwise, the same shall not affect third persons. Article 53. Either of the former spouses may marry again after compliance with the requirements of the immediately preceding article. Otherwise, the subsequent marriage shall be null and void. In other words, for the subsequent marriage under Article 53 to be valid, the following have to be recorded in their proper registry. 1. The judgment of annulment or of absolute nullity of the marriage. 2. The partition and distribution of the properties of the spouses. And 3. The delivery of the children's presumptive legitimes. If these requirements are not complied with, the subsequent marriage under Article 53 is null and void. Article 36. A marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. A presentation featuring psychological incapacity as a ground for annulment or declaration of nullity and the evolution of cases shall be posted soon. Article 37. Marriages between the following are incestuous and void from the beginning, whether the relationship between the parties be legitimate or illegitimate. 1. Between ascendants and descendants of any degree, and 2. Between brothers and sisters, whether of the full or half-blood. Article 38. The following marriages shall be void from the beginning for reasons of public policy. 1. Between collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree. 2. Between step-parents and step-children. 3. Between parents-in-law and children-in-law. 4. Between the adopting parent and the adopted child. 5. Between the surviving spouse of the adopting parent and the adopted child. 6. Between the surviving spouse of the adopted child and the adopter. 7. Between an adopted child and a legitimate child of the adopter. 8. Between adopted children of the same adopter. And 9. Between parties where one, with the intention to marry the other, killed that other person's spouse or his or her own spouse. Not included among the enumeration under Article 38 are the following: stepbrother and stepsister, adopted and illegitimate child of the adopter, guardian and ward, and surviving spouse of the adopter and surviving spouse of the adopted. So if you wish to know whether a marriage between Filipinos abroad is also valid in the Philippines, apply Article 26 first paragraph. If it falls under any of the exceptions, then it is not valid here, even if it is valid where it was solemnized. As to the status of children born of void marriage, Article 165 says, children conceived and born outside the valid marriage are illegitimate unless otherwise provided in this code. Article 54 states, children conceived or born before the judgment of annulment or absolute nullity of the marriage under Article 36 has become final and executory shall be considered legitimate. Children conceived or born of the subsequent marriage under Article 53 shall likewise be legitimate. In other words, as a general rule, children born out of a void marriage are illegitimate, except those under 36 and 53, which are considered as legitimate. If you find this presentation helpful, please hit the subscribe, like, and share buttons to receive notification of future presentations. Thank you.